Any other participant would like to ask any other further questions on this? You can maybe unmute yourself if possible and also shoot the question.
What happened to the corpus of the employee? You are on mute.
Hello.
Hello, sorry, I couldn't follow your question, Mr. Khanna.
No, what happened to the employee's corpus? So where that amount would be after employee's death, or how that the employee's fund would be, or the pension fund would be, his amount, his contribution.
That those things are not going to change because of this judgment. There's no change either because of judgment or the amendment. So it's only a question of whether you are entitled to a higher pension. So the corpus and things are going to be the same. So there's not going to be change. It's only moving from pension to, from provident fund. Part of the contribution would be moved to the pension fund. That's it.
Excuse me.
How this law will apply to the people who have changed the jobs in between and they have withdrawn their PF from the earlier employer?
It may not change much if they're still, because under the pension you need a minimum 10-year qualification. So if you're able to bring about a continuity because of your UAN, or you give your provident, because your earlier pension, what you contributed will also still be with it, unless you've taken away the pension component as well. If it is less than 10 years, then there may be a challenge. But if you've done 10 years with your earlier employer and you settled your dues, and thereafter you again join with a fresh employer, maybe even with a break, then you will have the benefit.
Thank you.
Excuse me.
This is Andrew.
Can I? Yeah, carry on.
Yeah, just wanted to check, sir. Somebody whose amount PF wage is much more than 15,000 even before 2014. Process is they need to write to the PF department asking them to take that amount and put it in the pension fund. Is it? How does it work, sir?
Yes. Yes, an option needs to be exercised. You're right, Mr. Andrew. So somebody before 1914 was more than 6,500, so not even 15,000. If more than 6,500, but the question would be if more than 15,000 will only actually arise as on date. So more than 15,000, if their contribution is being made, and even prior to 14, it was more than the ceiling amount they had been making a contribution. Then today, the Supreme Court said there will be a joint option exercised by both the employer and employee, and the Provident Fund will do the needful for extending a higher pension to the employee.
Okay. So it has to be directly dealt with the PF department or through the employer.
Hello, sir.
Sorry?
Am I audible, sir?
Yes.
Hello.
Yes, sir. Sir,
Hello.
Sir.
Yeah, just Ranganathan wanted to check whose responsibility is to calculate the.
Sorry, Mr. Ranganathan, your question was who will. So now there could be cases, especially in case of exempted trust. There is when there is going to be a joint. That's why the Supreme Court said there will be a joint option exercised. And once the joint option is exercised, the exempted trust would need to ensure that appropriate amounts are transferred to the EPFO. So the additional contribution that needs to be done has to be transferred.
Good evening, everybody.
Yes,
I have a question. Now, I retired in June 2014. My employer had contributed on the actual salary beyond the 6,500. Now, I understand from whatever you have said that we are eligible to go ahead with the higher pension. Is my understanding correct?
June 2014, you retired, but no option was exercised.
Yes.
Prior to you were not.
Sorry? But the employer has paid on the actual salary.
And you retired in June 2014.
Correct.
And there was no option that was exercised prior to your retirement.
Yes.
there seems to be a conflict in there because Supreme Court has said such persons cannot now opt for a higher pension.
Okay.
So if you look at 44.5, they have said that those who have retired prior to 1st September 2014 without exercising any option under paragraph 11.3 of the pre-amendment scheme have already exited from the membership thereof.
Correct.
They would not be entitled to the benefit of the judgment. So they have restricted it there.
Okay.
But to be honest, this is a very specific finding. But if you also look at just one paragraph before that, this is what I read to you as para 44.5 of the judgment.
Correct.
But if you look at paragraph 44.4, it shares the option can be exercised at any point of time.
Correct.
Therefore, there seems to be some conflict in that. So I think relying on RC Gupta, still an application can be made to the Provident Fund. It is wise, maybe sometimes Supreme Court may review this and find out that there is a mistake or conflict between the findings in 44.4 and 44.5 and correct it. So for what it is worth, it may be you can make an option and just see what the judgment, what EPFO has to say.
Oh, I see. Okay. So, but somewhere when we started, you said that if the contribution has been made on the actual salary, then you're eligible. What is it? What is it? What does that refer to?
No, that's what in your case, it has been made on the actual salary above the ceiling. So you fulfill that criteria.
Yes.
But you also after, and you should continue to be on roll after 1st September 14.
Yes.
That is what it is. That's where the Supreme Court has drawn a distinction between those after 1914 and before 1914.
Okay. So what you're saying is I can now give an option to EPFO or through the employer and ask for higher pension.
You could try. That's all. Yeah.
Okay. Okay, fine.
Sir,
okay. Thank you so much.
My question is, sir, actually when in 2016, sir, they deducted PF, sir. My salary is 24,500 rupees, but they are deducted PF from 15,000 rupees. They are not given any salary split up, but they are just deducted from PF from 15,000 rupees. And now this is question number 1, sir. Number 2 is, where do I find in the 2016 my salary was less than 15,000 rupees, because there was no salary split up given to us. In that case, how to ascertain that, sir?
That is something you can go to the Adalat. PF Adalat will maybe give you the details. But anyway, your salary is less than 15,000. So this judgment is not going to affect you, sir. You will be getting the maximum pension.
Okay, thank you, sir. Thank you, sir.
Sir, following to the Rama madam's question, so if people attain the age of 58 after 1 September 2014, and they are not entitled with the higher pension, so the pension restricted with the 15,000 only. So if now the employee wants to go, they already retired and getting the pension now, like 2016, 17 or somewhere after 2014 they retired. Now if they want to entitle for the higher pension, so how the system going to work out, and what the role here employer to play to help the employees to get the higher pension?
No, sorry. Your question is retirement in 16, 17. Yes, then you need to just give an option. That's all. Both employer and employee. Okay. Mostly one of the option forms or something will come, or even otherwise a letter saying that I wish to exercise an option in terms of the judgment of the Supreme Court should be sufficient.
Okay. Okay. So yeah, so we have to wait the guidelines from EPF for how this is going to be.
Yes.
Okay.
Sir, good evening. For an employee whose wage is greater than 15,000 and joined after September 2014, as of now, we can't join the EPS scheme. So, is that will that stay the same, or is there any change?
I'll leave contract.
Sorry. Therefore.
No. Is that remains
There's
the same?
No change in that, sir. There's no change. You will just continue to be under Provident Fund. So.
Okay. Thank you.
No, sir, good evening. I'm Parani from Kalishwari, which means if somebody retires after 58 and he continues to be in employment, he is still covered under PF, sir. That's what you're saying, sir?
No, that is immaterial. No, you don't need to cover a person after 58. That's not what I'm saying.
Okay.
After 58, you can always stop payment of contribution.
even PF and EPS, both contribution.
Yes.
Okay. Oh. So there is no mandatory after 58 years. That's what you're saying.
Yes, if that's the age of retirement in your establishment, there is no requirement.
Okay.
Thank you. Yes,
Right.
Good evening, sir.
Thank you, sir. Thank you, sir.
Good evening, sir.
Good evening.
Sir, my question is, sir, right now I am the member of PF Trust, and my salary and my PF deduction and pension deduction is made on this ceiling, that is 15,000. So, sir, can I opt for the option of higher pension?
No, sir, this judgment will have no application there.
But, sir, in prior to joining this organization, my PF contribution was deducted on actual basis then.
Even then, sir, unless your current employer is doing, which will be the last, there will be no point in paying a higher, unless the current employer is doing that, it will not be helping, because it's only at the time of retirement, 5 years behind what is it you paid is what is going to be taken. So 5 years prior to your, immediately prior to your retirement date, if it is taken, it will only be 15,000.
Okay, sir. Thank you, sir. Thank you.
Sir, good evening. This is Meghanathan, sir, from BPCL. We are an exempted establishment, and we have a lot of retirees in people who retired after 2014. So they are approaching us, and what is that we'll have to wait for the communication from the HQ of the PF department, or we can initiate process now.
For 1914, was your question that?
Yeah, exactly. Those who retired after 1914.
No, 1914, they're all not entitled. After 1914, if there is somebody who is retired, then you can start exercising options.
Exactly, sir. I'm talking about the employees who have retired after 2014. So they wanted to know whether they can submit the option form now.
Yeah, you can start, because the time limit of 4 months is there. Therefore, it is best to start it at the earliest.
And do we have to wait for the formal communication from the PF department, or we can initiate now?
So you can initiate, I think, unless somebody initiates, they are not going to be looking into it. So I don't know if there is going to be a formal communication. So it is better that you start initiating.
Yeah, and sir, those who are active employees like me, then we can take option form from them as well, right?
Yes, certainly.
Then about the contribution, we'll have to start from the 95 onwards. We'll have to see their basic, because our salary was always on the higher side, more than the ceiling of the pensions ceiling. So whether we need to calculate from 95 onwards, and we'll have to transfer that money to PF pension account.
Yeah, you need to first give the option, and once the option is accepted, or otherwise also there will be a requirement for you to transfer the additional contribution amounts to the EPF.
Yeah, we'll have to calculate from 95 onwards, right? When the scheme was introduced.
Yes.
Good evening, sir. I'm Shyam. Sir, anyway, this pension calculation it depends on the last 60 months contribution, right? So
Correct.
Only last 60 months I can extend the maximum contribution, sir. Till that time, can I contribute only on 15,000?
That's what we can't answer that. Yeah, that is one way of doing it. So if there is going to be a change in employer or something, and they decide to contribute, yes, they can. It's a possibility. I won't say it's. I don't think the act anywhere, or the scheme, pension scheme anywhere, requires you to pay. There is one judgment, I think, where they've said you can't do that. So okay. I don't know if that judgment will still hold good. But that is in fact the argument of the pension as well. So this is what you can do. And because they have said when you exceeded, you should have started paying, and that option. So, but sorry, sir, you can't do that. What happens now is you need to exercise this option within 4 months from today.
Okay.
From the date of judgment. So if you don't exercise it now, you can't now take it. So unless you are, let's assume your retirement age is 60 and you're today 54 years old, then maybe you can exercise now and take it forward.
Okay, but see, sir, my salary anyway, it's keep on growing because I have some 20 years service from now. So I can increase now. There is no capping, right? To
No,
increase.
but if you've already crossed 15,000 today itself, and you're only restricting to 15,000 today, there's no question of you exercising an option at a later point of time.
Oh, okay, got it. Thank you. Very good answer.
Sir, one small, sir, pioneer one taken from this Kalishwari. Actually, sir, when we start new project and it is only a construction stage, and till this either this commercial production starts, do we need to cover ESI, PF?
So we'll take these things offline, Mr. Paini. We are today only on this judgment. So any question on the judgments alone, please.
Okay, fine.
While transferring this fund from the provident fund to pension, and the member has already taken some advances for construction of house and so, and doesn't have a sufficient amount. So will it be okay that he pays on from his own hand and then it can be transferred to pension like this?
Yeah, he may need to repay to the trust and then the trust will pay it. That would be the way forward.
So what if it's an unexempted establishment?
Unexempted, it's for the PF to, PF will ask the employee concerned to pay back the amount. They will compute and say how much is to be paid back.
Good evening, sir. Good evening,
Good
sir. Am
evening.
I audible, sir?
Yeah, sure. Please.
Yeah. Good evening, sir. I'm Santosh Kumar from Mysore. I'm from an exempted establishment. Sir, some of the employees who have joined during 2017 when this option was not there, because they were after 2014 they were not included in the PF. Whether in this particular judgment, whether they will be eligible to give an option for higher pension?
Sorry, can you please repeat?
Somebody
joins in 2017.
Fresh employees. They were fresh employees. Previously they were not having this PF contribution also. So they are fresh employees. So they based on this judgment, they would like to exercise their option. Is it possible in this judgment?
No. Possible, provided they are members of the pension scheme. So if in 2017 they joined, let us assume on a basic salary of 20,000, which is beyond the ceiling, they would never be a member of the pension scheme. So they can't get the benefit. But if they join, say, let's 2017, the salary was 14,000, and today it's crossed 15 for a period of time, then they can give an option.
No, they joined in 2017. Their salary was about exceeding 15,000. They were paying to the trust. They are paying to a trust, but no pension contribution was not. EPS contribution was not there.
No, that does not change. That doesn't change. They can't join the pension scheme.
They can't join them. Okay, sir. Thank you.
Sir, sir, that means those join after 14 and exempted employee drawing 15,000 and above, they will not be covered again on actual salary. Is it so, sir?
They will not be eligible for pension.
So they will not contribute to the pension, even actual salary, since they are initially exempted drawing higher salary.
They are not member of EPS, first of all.
Yes. Huh? Yes, sir, they can't.
Sir, like for the proof of payment prior to 2000.
Sorry, your line is breaking.
For the Form 3A or 12A, like we don't have the documents. Can you hear me, sir? So my question is like, if the employer, like they ask the employee to submit the Form 3A and 12A prior to like 2012, like before ECR or online payment, and the employer doesn't have that original document which they submitted during that period, like will it be okay for them to submit the fresh calculation of the old whatever documents like 3A or 12A calculations?
I'm sorry, sir. On these procedural aspects, what PF is going to do is anybody's guess. I think they take a joint declaration. They want a declaration from an employer as well, and based on that, they proceed. That's how they've been doing all this. So I think they should continue this.
So, like last question, like they have given within 4 months to opt this option. So, provided like the PF also should give us the the clarity and the procedural.
So you make the option. Why are you waiting for anybody? First of all, employer and employee jointly should make an option. So you make the option within 4 months. Why should you wait for PF? They have not said anywhere the PF will come out with something, then you have to apply or anything. 4 months time is there, therefore for you to apply. That's all.
Yes, sir.
The judgment is talking about kind of additional contribution of 1.16 percentage by employees. What is your take on this, sir? And what is your advice?
No, the 1.16 is within the 24%. So 12% employer, 12% employee. Current, what is being happening is employee share from that 1.16 is being taken and put into pension. That's what has been happening from 14 onwards. They have said that can continue till 2000 for another 6 months. And then it is for the they want to continue on this or not.
So there is no additional cost to the employee. This is what I understand.
No, there is no additional cost.
Okay, thank you.
So 1.16 is paid by the employer or employee, sir? I didn't get that, sir, please.
No, there is no additional, first of all. There is only 12%.
Okay.
As of now, the 12% of employees straight away goes to PF.
Okay.
But because of this, in 2014 amendment, out of the 12%, 1.16 was in excess of 15,000. So whatever is the amount in excess of 15,000, in that 1.16 goes from the employee's contribution of 12% to pension.
Okay. So it will be 8.33 plus 1.16, sir. Is it like that?
Over and above 15,000.
Exactly. Okay, sir. Thank you, sir.
Thank you, everyone. Thanks for joining. I think with this, we'll close. Please feel free to write to us if you have any queries. Thank you.
PPT, sir, if you can share, because I just lost some of the slides in the beginning.